So, Tara, I want to talk a bit about your approach, the approach that you advocate in the book. And as you know, there are lots of different interpretive methods. There's a whole debate out there about what's the right interpretive method. And there's names for all of them, originalism, textualism, whatever. Do you have a name for yours?
No. And now you're talking about the approach that the court should take, right?
Yeah,
Judicial review. Yeah.
That court
you
should
know,
take.
I wish I did. I don't have a great name. I mean, I think it's the objective approach.
Yeah.
You know, it's the objective way to discern the actual meaning of the law, but I don't have a snap. Yeah.
So that's fine.
I mean, I do emphasize it's not originalism, and
Yeah.
I talk about that.
Yeah, and that's what I want to get into. So if you can describe, if you can, sort of summarize what your approach is, or what it's, what it means, or what the approach is, and distinguish it from some of the other major ideas out there or approaches.
Sure. I mean, a court in judicial review, judges, they need to be objective. And that's the reason why I go into, in the first part of the book, what is that? What is it really to be objective? Because I think most people are very confused about that. Whether they're talking in the context of law or in many other fields, while again, people want objectivity from their jurors or from their journalists or from their medical researchers or whomever, it's one thing to think they know it when they don't see it. It's one thing to, complain, I was passed over for the job non-objectively and so on, but it's another to say what it is. I think we're all kind of confused about it. We fall into these misconceptions about objectivity itself as value-free, not just a legal system, but anyway, and I try to distinguish it from all of those. So in part what I'm saying is simply, judges need to understand what it is to be objective, and they need to be objective in the treatment of specific laws, specific disputes. But let me say a little bit more about, I think, what that cashes out as for courts. They need to understand the contextual nature of any given law. Maybe it's a First Amendment case they're hearing about freedom of religion or freedom of speech or freedom of the press. Maybe it's a Fourth Amendment case about search and privacy. Maybe, whatever the particular piece of law that they're dealing with, and those are just examples from the constitutional level. They need to realize the contextual nature of any law, and part of what I talk about there is they have to realize that individual laws can be properly understood only in light of the principles that inform the legal system as a whole. And those principles themselves are a reflection, again, of the ultimate purpose or function of the legal system. Right. In many areas of life, people readily understand the idea of the letter of the law and the spirit of the law. And sometimes in unusual cases, they'll say, well, yeah, technically the letter would dictate such and such an action, but the spirit of the law was this. Well, basically, that's a way of recognizing context.
Yeah.
Context matters to how it's rational to apply a general rule in particular circumstances. That kind of appreciation of context, that a given law can't authorize the government to do more than the government itself has the authority to do, that kind of thing is itself incredibly helpful for courts. The other thing that I stress in talking about how does objectivity cash out for courts, judicial review is, and this one is really simple in a way, but amazingly heavily abused. Courts have to focus on the law and nothing but the law, and not all these other things, all these other red herrings and distractions that they and we are constantly talking about when we think about, oh, the judges should do this, I hope they do that. For example, how is this going to play in Peoria? Now, people don't put it in those terms, but we continually hear, well, if we rule this way, it'll be very divisive. This is a mainstream position, as if either of those has anything to do with what the law, what the Constitution says, right? And that's what they're supposed to, right? They're not the politicians who are trying to, they're not daddy trying to make nice among the feuding kids. Okay. We hear, oh, well, the French are so enlightened about juvenile punishment, or so there's these appeals to foreign law, or these, I get excited when I start thinking about these nebulous terms like deference and balance, and they sound so moderate and reasonable. And courts are again counseled, well, you should stick to the narrow path. This is something big for the minimalists, or just balance the competing concerns. Look, if the Constitution decrees something and that's out of whack, wildly imbalanced with what a whole bunch of people want, the court's job is to uphold the law. So one of the things, and again, I go through this in a more systematic way, very simply but crucially, if objectivity is a matter of trying to understand, get some object right, trying to understand it accurately and fully, for the courts, the thing they're trying to get right is the law, the existing law. It's not their job to make the law better, even if they've got a true idea of how to make it better. That's not their job, right? They have to stick to their function, which is illumination of what the law means, what it requires, what it forbids, how that applies in the given case. So again, I elaborate on focus exclusively, unswervingly on the law, appreciative of the larger context of the authority of the legal system and how that.
Let me read you another quote here, because this one touched me, because as a lawyer practicing for many years, I've had to deal with courts doing all kinds of things, such as you're criticizing. So here's the quote. The objective interpretation of law must be holistic. A proper constitution is not a scrapbook whose cut and paste contents each carries a freestanding meaning and authority. So, I mean, you're speaking to something that's actually going on in the world. Elaborate on that a little bit. That kind of what it is that the scrapbook approach to the Constitution.
I mean, people focus on phrases out of context, like forgetting the larger meaning. So, for instance, I don't know. Maybe this is an example. I mean, sometimes the way the right to free speech is spoken of. Good amendment, the First Amendment. I have no objections to the First Amendment, okay? Good to protect, proper, in accord with the function and authority of government to protect individuals' freedom of speech. But freedom of speech, so shouldn't I be free to say absolutely anything? I mean, people just, well, no. Because you should only be free to do what an individual has rights to do, because rights are the abiding principle of the entire Constitution, and it's the government's job to protect rights. And if you had the freedom legally to say absolutely anything, to fraudulently misrepresent that hair tonic you're selling or something, that would obviously be at the expense of the other people who are deluded through no fault of theirs and through every deliberate knowing fault of yours. So, I mean, that's just one example of the ways in which, taken out of context, like a scrapbook, given phrases can be given meanings completely at odds with the proper meanings. Now, at the same time, to figure out the proper meanings is sometimes difficult. And that's why we need judges. That's why we need smart, thoughtful people who understand the framework of the whole, the holistic picture of government and the authority of government. And they need to reason well, but reason objectively to figure out the right answers.
Okay. Tara, thanks a lot for both writing the book and for talking about it
Thank you very much.
Today.
Okay.
Thanks.